Hello, Regulation Theory students. Dr. Conway here for Lesson 7 on Information and Evidence in Regulation. This is a really important topic because it takes us into some of the stages of regulation design, performance review, and so on. In other words, what we call the life cycle of regulation. I'm going to go through this lesson, and I recognize that it will take some time to digest all these stages, but we will be revisiting a lot of these stages of the regulation life cycle where information and evidence is particularly required through much of the program, including the rest of this term and next term. But this gives you an overlay of how information and evidence is so critical in regulation development. Okay, so let's get started on that now. So the information basis of policy making plays a really important role in maintaining the legitimacy, transparency, and accountability of government in general. And we discussed this right through the first lesson in particular, but when we talked about the fact that the legitimacy, public legitimacy of the regulatory process is critically important. And most of that legitimacy, considering that regulation development is delegated into the bureaucratic system of a minister responsible for any legislative act, the importance of the public's expectation for high levels of expertise and high levels of evidence, including scientific evidence, is particularly acute if we want to maintain those high levels of public legitimacy, therefore high levels of voluntary consent. Now, most of you will remember all this discussion that we've had, so this lesson fits very much into that sort of genre, okay, of issues, and why it is so critical to talk about evidence in the abstract is to understand its vital importance in terms of maintaining the legitimacy of the regulatory process. Okay, this is, like I say, particularly relevant because we're dealing with unelected regulators, right? And public legitimacy is largely based on trust in the expertise of the regulator. In fact, from the perspective of the Government of Canada, and this is true of most democratic countries, it is the duty of regulators to respect Parliament and authorities granted by Parliament as expressed in legislation. And we've discussed the legal infrastructure of regulation already, right? That one fits clearly with that. Ensure that regulations result in the greatest overall net benefits to current and future generations of Canadians. And that's the issue of scarcity and opportunity cost, and the public's desire to see the government protecting them from harms, right? We've discussed those issues as well. And in fulfilling the duties, government departments and agencies should be guided by 4 principles according to the Government of Canada, all right? 1, regulations protect and advance the public interest and support good government. Regulations are justified by a clear rationale in terms of protecting the health, safety, security, social, and economic well-beings of Canadians and the environment. Well, you can read scientific evidence and evidence of other kinds right into that one, right? A justification that regulations are being taken to protect the health, safety, security, social, and economic well-being of Canadians. And this also relates to our lecture on rationales for regulating free markets, right? Don't forget that, because we can see that there are different rationales, different areas where regulation protects the public from harms, okay? The regulatory process is open and transparent. That's number 2. Regulations and their related activities are accessible and understandable and created in an open, transparent, and inclusive manner that engages the public and Aboriginal peoples as required by Supreme Court rulings. All right. So, this again speaks to the public's opportunity to see the evidence on hand, right? To see the justification for regulation and to comment on it, right? And that's, again, a core ingredient for maintaining the public legitimacy of the regulatory process and defending the integrity of regulatory outcomes, all right? And so that becomes critically important, and that's why we have Gazette 1, Gazette 2, other opportunities for consultation and so on, right? To maintain those high levels of public legitimacy is critically important. Regulation decision making is evidence-based. Well, proposals are made and decisions are based on evidence, robust analysis of costs and benefits, and the assessment of risk while being open to public scrutiny. And we've discussed this, right? We've discussed scarcity, opportunity cost. We've discussed risk assessment as opposed to hazard as a basis for regulation. And this places robust burdens, extensive burdens of evidence onto the regulatory process before regulations will ultimately be approved, right? And that's why regulations can take a long time sometimes to gestate in the system as all this evidence is gathered and before a regulation is actually developed, all right? Regulations support a fair and competitive economy. So you have this dynamic, right, where regulations, yes, have to protect the public from harm, but they have to do so in such and such a way that the economy is not unduly burdened for scarcity and opportunity cost reasons, for competitiveness reasons with other countries and so on, right? And so there needs to be some kind of a understanding of the relationship between regulatory objectives and economic costs and burdens, right? And we see that a lot in the second term when we talk about having to do regulatory impact assessment statements and other types of activities that look at the economic implications of action, right? Not that the objectives should be overridden by economic considerations, but obviously economic considerations need to be known. This ties back to the public interest, private interest school we've discussed, right? It also ties back to the need to have a regulation that can actually be implemented when it's put forward to the people. There's a prospect that it can actually be implemented without undue costs that will undercut the public legitimacy of the regulation. I mean, if you regulate something and tens of thousands of workers lose their jobs, the public legitimacy of that regulation is obviously going to come under challenge. So a situation like that may require phased implementation over an extended period of time as the economy adjusts, much like what we're seeing right now with climate change and the oil and gas intensive provinces in Canada, right? It's a whittling away over a period of time as the economy adjusts, okay? And all of these requirements that the government places on regulation, the regulatory development process, are very information intensive, information and evidence intensive. And this concept of understanding the intensity of information requirements for regulation is best understood through what we call the regulatory life cycle approach, which now the Cabinet Directive on Regulation federally demands that all departments consider the entire life cycle of a regulation as it's being developed, and that must be there before it will be approved by Cabinet, okay? The life cycle of a regulation includes the development of regulations, regulatory management, all the way through to review and results, okay, of the regulation. And throughout this whole process, there's this public transparency, and the public is expecting, particularly industry groups who are impacted by regulation or others who are impacted by regulation. People are expecting high quality information to justify action, and for good reason, right? I mean, scarcity and opportunity cost. It shouldn't be an issue of where you are on the political spectrum to say that yes, there is scarcity, and yes, there is opportunity cost if we make improper moves on regulation, right? I mean, if we can achieve objective in a more cost-effective, cost-efficient manner, obviously we should be seeking to do that. The difficulty becomes when, how do you know? And that becomes the political part of a regulation. When I say regulation is always fundamentally political, right? That in addition to the fact that all regulations to one degree or another redistribute wealth, right? From those being regulated to the benefits accrued by other people who are not being regulated. All right, so let's look at the regulatory life cycle and how information intensive it actually is. Let's take a look at regulatory design stage, in which has a number of sub-stages, right? The first being problem identification. All regulatory processes should start off with an argument for a compelling public need to address factors contributing to a harm. And you recall in previous lessons we've talked about the need for prioritization of regulatory objectives due to scarcity and opportunity costs. Because no government, no matter how wealthy, can regulate all issues that it would like to. Never will there be a situation where all harms are fully and comprehensively regulated, because that would be impossible from a resource perspective within government and within the private sector. So you're always looking to prioritize, and prioritization means that you have to have the scientific and other evidence to justify regulatory action because of scarcity and opportunity costs. You can't regulate everything. So information requirements must relate to the hazard, the potential exposures, and the subsequent risk of harm that must be controlled. Is it serious? Is it significant enough that the government should be advancing a regulatory agenda in this area? And because regulation is used in almost all spheres of government, as we've discussed when we looked at the areas where free markets can be regulated, the information needs for problem identification can be from almost countless sources: scientific, socioeconomic, business, cultural, and ecosystem analysis, you name it, depending upon the nature of the issue. So if you were to look at all of the resources in government that are devoted to in one way or another to the regulatory life cycle in one sector or another, it would be a humongous portion of government. All right. The important point is that this type of information is critical to decide between possible scenarios. One, is there a minimal or no harm or risk of harm? There can be a harm, but the harm can be such that this is a cost that society is going to have to bear to maintain the benefits that it's receiving from a certain activity, but the harm isn't severe enough to justify a major regulatory action. And that's where things like suasion could come in, and other types of policy, lower threshold policy instruments, right? Second, harm is or likely will be easily remedied. In those cases, governments might see that the evidence dictates that there isn't enough justification for comprehensive regulatory action, but other policy instruments could come into play. All right. 3, harm is or would likely be restricted in scale or effect. Sometimes those can be very targeted measures, right? Where government consults with industry, seeks a voluntary approach, or alerts the industry to the fact that if action isn't taken here, there may need to be government action, or there may need to be public pressure applied by reporting to the media and letting the media point the finger at the industry. There's all kinds of different things, right? So if it's restricted in scale and effect, it might still be important, but the government elects to approach it from a different perspective. That too has to be justified, right? The next one, there's significant or widespread harm or potential for such harm. Then, the government starts to think about this in terms of regulatory action. Finally, harm is actually or potentially caused to a vulnerable section of the population of the built or natural environment. And if it's a significant harm, that may require regulatory action, all right? And that can vary quite comprehensively depending upon who's being affected, how urgent it is, whether it's acute or chronic, how severely chronic is it, a number of factors. But all of those decisions, right, on those questions I just asked very quickly now, must be answered through evidence of one kind or another, which is resource intensive to gather, right? Second, modifications to existing rules, right? If a discovered harm indicates the need for a policy of intervention, it might be, you need to justify what kind of policy intervention, and that can be also evidence intensive, right? It might be that an existing policy instrument already working in the area could be revised to better address the factors of harm, right? Or it might require a completely new regulation, and that is an analysis that needs to take place based on evidence. Assessing this possibility requires information be very specific as to how some factors contributing to harm have changed, what countermeasures are needed. That's in the case we already have a regulation. And if you're saying this new discovered harm could be addressed by that regulation, you're essentially saying that there's some factors that regulation was supposed to address that are no longer being addressed, or there are new factors have arisen that aren't being addressed. But we may be able to revise this existing regulatory instrument to address it. And that's why we often have amendments and consolidated amendments of regulations, because regulations are not infrequently revised in that way. For example, it could be that action is necessary to clarify a gray area in an existing policy instrument, or to deter a behavior that is new or beginning to worsen as a factor of harm, right? So the regulation gets tweaked. In other areas, you might be developing a completely new regulation because no other regulation is suitably revised to be able to account for that. But you can see, to make these decisions, you have to have very specific information, right? As to, why can we use this existing regulation? Well, really because we're talking about the fact that new technology or some other occurrence has transformed the cause and the causal factors of harm and we need to revise the regulation to address that. All right. Assess policy instrument alternatives. You recall from an earlier lesson that we need to, we can't just jump to regulation. There has to be evidence that other policy instruments would not be sufficient to address the factors of harm, right? And you need evidence. I mean, you need to be able to understand how the other policy instruments would work on the factors of harm that we're considering influencing, and saying, could another policy instrument do that? And so now you have the research on the factors of harm, but you also have the research on how the policy instruments would influence those factors of harm, right? So that becomes additional intensive activity. And we need to do this because we know that policy instruments are differentially suited to the factors that regulators are trying to influence. For example, in some areas of harm, it might make perfect sense to use regulation because the involved entities are relatively similar in terms of factors of harm. There are fewer of them. They all basically function the same way. They're all contributing to the factors of harm in pretty much the same way. So regulation makes perfect sense. On the other hand, when entities are highly dispersed, differentiated in technologies, techniques, and processes, and subject to variable capabilities and constraints for compliance, it might make sense to look at other instruments, like economic instruments or public suasion or something like that to have effect, because in those cases regulation is not going to be highly effective. Or it can be done, but implementation costs, right, compliance, promotion, and enforcement costs would be exceedingly high. Right, so which doesn't do what? Doesn't make the policy response the most cost effective and the most cost efficient. All right, and so we wouldn't want to go in that direction. And so information to make these decisions must be relatively specific to all involved factors of harm and up to date with changing circumstances. So, you need to be able to understand both the factors of harm and the behavior of policy instruments in that context to determine what is the best policy approach. And that takes time. And that takes, evidence gathering and analysis. It is also a fact of life for regulators that they must identify and justify trade-offs between economic and other objectives as an explicit part of decision making. And so when you're making those choices of policy instruments to use, you're considering influencing the factors of harm, but you're considering influencing the factors of harm in the most cost-effective and cost-efficient way, which is now a third layer that you have to layer on there, right? This requires sound economic information on the factors of harm, all right? Then you get into the right regulatory design. Again, information intensive. Compliance requirements for any regulation can be, and not infrequently are, highly political. We know that, right? And so under these conditions, information must be able to justify the rationality and the proportionality of action on regulatory requirements. So the rationale for action, but when you get into design, you have to talk about the proportionality of action, because different regulatory designs will have different proportional relationships to the objective of harm reduction you're trying to achieve. Some might be very heavy-handed and achieve the objective. Some might be less heavy-handed and still address the lion's share of a regulatory objective. So you have to make that trade-off. Do we pay that a more extensive economic cost or a slightly less economic cost to achieve most of the regulatory objective? Okay, and this is why regulation is always going to be fundamentally political. Okay, and this typically requires intensive and highly defensible information, because we're now talking about hitting the regulated parties in the pocketbook, right? And we're asking that we're taking money from there to provide benefits somewhere else. That's always going to be highly political in any political system, right? So scientific, socioeconomic, cultural groups, differentially impacted, every people's gender. There are so many different people that are going to be differentially impacted by regulatory design as well, right? Regulatory design isn't going to hit all groups the same way. It isn't even going to hit all industries that are being regulated the same way, because some regulations, some industries will already be further ahead than others. Like multinationals will usually shrug off Canadian regulations because they're operating in the EU and the US and everything anyway, and so their internal processes are probably already in compliance or very near in compliance. For them, they go, nah, okay. But for small and medium-sized enterprises, for example, the regulatory design and supporting policy measures around that design, which we'll talk about more in the second term, will have a quite significant influence on their ability to comply, right? And then you have, through this whole thing, you have the thresholds and the regulation of science that come involved, right? How much of the threshold that are where we're trying to achieve can we, threshold in terms of exposure levels are we trying to achieve, and how fast is a really important consideration. How fast do we need? What is the health science telling us about the levels of risk, such that how fast do we need to achieve this objective, or can it be phased out over time because the economic cost of trying to do it all at once will be too high? All of these factors come into play. All right, and then on top of that environment economy dynamic, you have the areas that science must know of the factors of harm in order to be able to design a proper regulation. For example, depending on the situation, governments might need to address chemicals as all three things: products, right? Constituent parts of products, so they might be regulated out of products or phased out of products through regulation over time. Constituent parts of products, right? They might be used in building other products, okay? They might be, it might be a certain kind of paint that you're trying to get rid of that's on toys, or whatever the case may be, right? So you have to figure out, well, what are the factors of harm there, and how is my regulation going to impact that? And then you might have to, the same product you're regulating might also be used in production processes, not constituent parts of the product, but used in the production process. For example, cleaning computer chips or whatever the case may be. And so your regulation has to be able to capture that activity as well. And how's it going to do that? So what point of intervention are you going to get? So let's say a chemical product is used for both. It's a product itself, it's used for a constituent part of a product, and it's used in a production process. All of those three things. How are you going to design a regulation that addresses all those three areas of harm associated with that product effectively? Typically then you need to move upstream, right? You need to move to where the decision being taken to use that product in the first place, or to design that product in the first place. So all these questions need to be thought through, right? But all of these factors are fed into a scientific process that characterizes the level of risk and what areas of risk you want to control. And that considers a whole bunch of things, right? Many things you're discussing in your other courses, no doubt. The hazardous properties of the chemicals, nature and extent of the hazards, situations that expose people in the environment to those hazards. You should all know the formula now: hazard times exposure equals risk. Extent of exposures, including for different groups in society and components of ecosystems. Establishing acceptable risk thresholds and uncertainty factors. And that has to be done for subgroups of the population, right? You've learned that, how a chemical might affect a 30-year-old healthy male as opposed to a young child or a pregnant woman or something is going to be different, right? So levels of exposure imply different levels of risk, and so all that has to be thought through in the regulatory infrastructure as well, right? Risk management, risk characterization options all have to be considered through intensive information requirements, all right? Performance goals and measures for outcomes and outputs, right? This is a requirement, and you're going to learn that as we go through the process. But before you can even get a regulation approved, you have to have a strategy for regulatory evaluation. It has to be a document that sets out the baseline. It talks about how you're going to review this regulation in 5 years, and that has to be there before Cabinet even signs off on the regulation in the first place. And that framework has to be used to review the regulation down the road, right, for performance goals and measures. So the regulator must have a grasp on how factors of harm can be influenced by planned policy measures. In other words, when you're developing your review framework, you have to set out criteria that says that this is how we anticipate our regulatory design is going to impact this problem. And then in 5 years, you use that framework that you needed to get the regulation approved in the first place to evaluate. Did that happen in the last 5 years? Yes or no? All right. And this is usually set out in what we call a results-based management framework. That's a whole area of work that I won't go into in detail here, but you can Google results-based management framework and see some of the matrices that are set up for that, okay? I'm not going into this section in a great deal because that's a major part of your second term course in post-market surveillance, where we will go into this in much greater detail, okay? Then regulatory decision making, right? We have the expected benefits, costs, and other impacts need to be considered through what we call a regulatory impact assessment statement. And I won't go into this in much detail here yet either, because you have a whole course on socioeconomic analysis for regulation in the second term, which I also will be instructing, okay? And these sections here just lay out the various objectives for the RIAS, the various components of a RIAS, I mean. But again, I'm not going to go into this in a lot of detail now because we have a whole course on it in the second term, all right? So, and then, there's performance review, right? Where you had to set out your review framework before the regulation was even involved. But then when you do the performance review later, you have to go through all of the data where we write about the data. Has the data changed? Have the causes changed? Have the exposure pathways changed? All of these factors during review are very resource intensive as well for information, right? Again, I'm not going to go into this in great detail here because I want to expose it to you in these slides, but we have a whole course on these issues in the second term. Okay, so the purpose of this exercise is to show you the research intensiveness of regulatory decision making and why it's so important to have that. And you understand that for when we look at regulations to say, why does it take so long? Well, why do we have to have so much information? Why do you need to do a cost-benefit analysis? All of that needs to be understood into those core concepts, of risk versus hazard, right? Of the need to regulate based on concepts of scarcity and opportunity cost. The need to make good decisions in regulatory design for subgroups of the population that may be differentially impacted. All of these concerns, perfectly legitimate concerns, impose an evidence obligation on the regulatory process. And that's why regulation can be so evidence intensive. It can be very demanding. You don't just throw a regulation on the books that could cost hundreds of millions of dollars for the society to implement without having very clear notions as how that's supposed to be addressing an issue of harm. And what extent do we think it's going to be effective at doing so? And then reviewing it 5 years down the road and saying, were we right or were we wrong about this whole process? All right? On that score, I'll let you go, and we'll be talking to you next time. Bye-bye now.